We're now recording.
Okay, thank you, Janelle. So good morning, everyone. The current time is 10:04 on October 24th, 2024, and the meeting will now come to order. Please note that this is a remote meeting like a regular in-person meeting of the Privacy Law Group, and the meeting will be recorded and archived on the State Bar's website. The Privacy Law Group will take items on the agenda in the order that they appear, and votes for any items will be taken by roll call. So we will begin with the roll call with Jeanette.
Can you guys hear me? Perfect. Let me start with Kareem.
Here.
Play.
Here.
Serrato.
Say Serrato.
Yes.
Present.
Martinez.
Present.
Froelich. Froelich.
Present.
Thank you. Israel.
Here.
Jaworski. Uwanka.
Here.
Lanoy. Hershenson.
Here.
Davis.
Present.
Rajmohan.
Present.
Choi.
Present. Good morning.
Good morning. We have quorum.
Hi, everyone. It's Mariah Jaworski. I think I missed the attendance, but I am here.
I will note that. Thank you.
Thank you. And Janelle, would now be a good time to talk about the changes in officers?
Right. Well, I wanted to welcome everyone. Thank you for joining us for this meeting. As you know, I have been serving as chair for the last year and a half, 2 years. And I am happy to now pass on the officer duties to Ryan Davis, who has been serving as the vice chair for the last for the other meetings, and Lindsay Krolik, who will be serving as the vice chair for the meetings starting from today. So please welcome Ryan as the chair for the consulting group. Thank you, Ryan and Lindsay.
Thank you, Jawan. Okay, so we will now move to the call for public comment. The Board of Trustees recently adopted a public comment policy that applies to all State Bar committees, including this one. Its policy statement says the State Bar welcomes public comments at all of its public meetings and appreciates listening to a wide range of viewpoints that reflect the diversity of California. The public comment rules are designed to ensure that members of the public may exercise their right to be heard, as well as ensure that the State Bar is able to fulfill its obligations to conduct public business on behalf of the people of California in a timely fashion. Written public comment may be submitted to the email address on the meeting agenda. We encourage you to submit written public comments at least 24 hours prior to the start of a meeting. And written comments received less than 24 hours prior to the start of a meeting will be distributed the following business day. If you bring written materials to a meeting for distribution, they will be collected by the meeting secretary and distributed after the meeting concludes. For oral public comments, persons were encouraged to sign up to speak in advance of the meeting and will be called in the order they have signed up. Persons attending the meeting remotely will be called in the order that they appear on the attendee list. And in a moment, I'll explain how to raise your hand to tell us what that you want to do that. Speakers cannot cede their time to another speaker. It does not guarantee that all who wish to speak will be able to do so to facilitate hearing from as many members as possible. We encourage you not to repeat points that were made by previous speakers. Simply say that you agree with them to allow the committee the time needed to deliberate on the important topics that we will be discussing today. We will be limiting public comments today to 2 minutes per person. And as a reminder, the state bar's anti-discrimination and anti-harassment policy says the state bar maintains zero tolerance for unlawful harassment, discrimination, and retaliation. Employees must at all times treat all other employees, job applicants, and persons providing services to the bar with respect and dignity in accordance with this policy. Likewise, the state bar will not tolerate harassment, discrimination, or retaliation against its employees, job applicants, or members of the public by any employees or any person with whom the state bar has a business, service, or a professional relationship. If you are in Zoom and want to speak, you'll need to raise your hand unless you are already on the pre-meeting sign-up list. To do so, you click on the hand icon at the bottom of your Zoom window. If you're participating by telephone, you may virtually raise your hand by pressing *9. That's the star key and then the number 9. And our coordinator will call members of the public, starting with the pre-signups, then the Zoom list, followed by in-person signups in the order that they raise their hands or sign up. Staff will enable microphones of the speaker, start the timer, and then call out when 30 seconds remain. Do we have anyone that wishes to make comments? I don't believe we have any planned guests today.
There was no pre-signups, nor were there any hands raised.
Okay, thank you, Janelle. Well, with that, at this point, I'd like to welcome everyone again to this meeting of the Consulting Group on the establishment of a legal specialization in privacy law, and I thank you for your attendance. We're going to begin our business with the approval of the August 29th, 2024 open meeting minutes. We ask that our attendees take time to review the minutes and ask for a motion to approve those August 29th meeting minutes.
Unaka here, I'll move to approve.
Michael,
Workey seconded.
thank you. We will now vote by roll call.
Fran,
Approved.
Calais, Serrato,
Approved.
Martinez, Krolik,
Approved.
Isri, Michael, I don't hear you, unfortunately.
Sorry, can you hear me now?
Yes.
Approve.
Thank you. Jaworski,
Approved.
Unaka,
I vote yes. Let's go.
Lenoy,
Approved.
Hershenson,
Approved.
Davis,
Approved.
Rajmohan,
Approved.
Choi,
Approve.
with 11 yeses, and the meetings are approved.
All right, thank you. So we will now move on to business with item 3.1 on our agenda. And this is a discussion of the action and proposed standards for exam specifications in privacy law. And I'll be helping to facilitate this discussion. I believe, Lindsay, were you going to share your screen for this one? Are you, okay, thank you. And just to kind of summarize, these are the main categories and subcategories of the general topics that the PLG recommends for an exam for specialization in privacy law, and what that exam should include. The PLG worked on developing these categories, and Jawan and I then worked together to eliminate some duplicate categories that came up, where we saw topics coming up in more sections than just one, and we refined the list a little bit with a little bit of combination where we thought that made sense. I will quickly run through the sections and I'll give you an opportunity to make a comment. But these lists are very similar to what you've seen before. The one big change that we did discuss and we'd like the PLG to talk about today is potentially removing section 8 intersection, which is still on this list you'll see today, but we do want to talk about that. So, but before we do that, I'll just run through the other sections, starting off with PR. As you recall, each specialization exam has a PR section. And so here we have our ethical obligations of a privacy specialist, duty of competence and diligence, confidentiality, loyalty, to notify or report, data practices, data mapping, safeguarding client data, emerging ethical issues on privacy and technology, attorneys' use of AI, client or confidential data, and evaluating new technology as a privacy law specialist. And I want to give us an opportunity to make a comment, given what our current final list looks like right here. So any comments on that one?
So I have a question slash comment, and I guess I don't know if this is for staff or for the board, but as the public member, you know, there's only so much expertise I have in the actual law behind privacy. So I rely more on the attorney members on this to present it. So you know, I'm comfortable in listening and paying attention, but in terms of validating these individual steps and standards, I'm not sure I'm the best qualified to be commenting necessarily.
Well, Robert, I think the idea is as a public member you have that to have insight, you know, on on some areas. I don't think it's a requirement for you to know, you know, absolutely everything about all aspects of privacy law. So you're right, there is this dependency on other panel members. You know, everybody comes here with a unique perspective.
Sure.
Your background is you know, technical and having prior experience in this area.
Yes.
So I don't think that's anticipated. So
Okay,
but
I just wanted to
thank you
make
for
sure in
raising
terms
that.
of my participation in voting is, you know, yeah, obviously I'm coming from more of a layperson's perspective, but with an understanding because of my background in IT and in working with it. So.
Oh yeah. Okay, great.
Okay, well, if we have no other comments on section 1, I'll move on to section 2, which is principles, which we found this is valuable as kind of overarching concepts that are fundamental to privacy law. They really do crop up in each of the other categories, but are rather fundamental to just being a privacy law attorney. They include notice and transparency, consent and opt-out, access and data portability, accuracy, security, accountability, purpose specification, data minimization and proportionality, non-discrimination, and storage limitation. Any comments on this one? Soyan, did I see your mic come off?
No, I think my mic's been off, but I didn't say anything.
Okay. Okay, well, if we have no comments on that one, then we have data collection, which includes notice at collection, online and mobile application privacy notice, online tracking technologies, offline privacy notice, collection from third-party sources, consent and authorization standards and requirements, data brokers, targeted and behavioral advertising and marketing, and enforcement and private right of action. Any comments here? Okay, moving along, we have emerging technologies with health tech, wearables, fintech, autonomous vehicles, social media platforms, Internet of Things, AI, virtual reality, augmented reality in the metaverse, NFT and blockchain, biometrics, genomics, neural technologies, cloud infrastructure, robotics, and other emerging technologies. Just kind of a grab bag. Any comments here?
Hi, this is Michael. Just a comment. I love the fact that for emerging technologies, I don't think I see anything relatable to phones anymore. So I think phones are no longer emerging.
Thank you.
Is the list expected to be updated regularly as well, or not? That's the challenge, with having a list of emerging technologies, right? And I think that's, the point as well that Michael was raising, is the fact that today the technologies listed here may be emerging, but then who knows, how things will be like, in a year from now. And, for example, AI, it's being implemented everywhere, and I suspect that it won't really be called emerging, for too long, or even NFT and blockchain. Is it really emerging now? I don't know, because it was already introduced a while ago, and so forth. So that's the challenge that I'm seeing, is the fact that having a list of emerging technologies does mean that it needs to be constantly updated and maintained.
Was that a question, Paul?
Yeah, it was a question on whether we are going to have to.
We can't. So we can. I think that we just need to be careful. I would say maybe like within 3 or 5 years. Every
Okay.
3 or 5 years. Just because we provide this to the public so that applicants know what to study. But if we're constantly changing it, it becomes unfair to the applicants, because
Yeah.
they're going to constantly have to change like their studying habits, or what to expect on the exam.
Or maybe we should call it something different, not emerging technologies, but we call it something like, I don't know, significant, or something, where there is technologies with, huge, sorry, technologies with a potential privacy impact, or something like that, so that it doesn't, so that the list doesn't need to be constantly updated. Another item as well, social media platforms, are those really emerging? I would argue that a platform like X or Facebook, they're not really emerging. They've been around for quite a bit, right? So it's the word emerging maybe which which I'm struggling with here.
Paul, what do you think about saying just technologies? So we can remove
Yeah.
the word emerging.
Yeah.
And so I think it's understood, because this exercise is to highlight the topics, right,
Mhm.
from which exams can be written. So obviously the exam is going to be privacy issues related to these technologies. So
Mhm.
we could just say technologies.
Yeah.
Hi,
Then-
this is Soyan. Oh, sorry.
Sorry, I was just gonna comment, we can also keep the 4.15 other emerging technologies at the end, just to show that we are thinking forward.
Right. I was part of the group that worked on this, and there was a tension, of course, the tension, Paul, that we did address, because we did want it to have the sense that it is technology in a way that isn't obsolete. For example, VHS tapes.
Yeah.
On the other hand, it couldn't be too cutting edge, because then it would disadvantage people, practitioners who wouldn't have necessarily like the cutting edge. And so that's why, social media to us now may not seem like emerging. So I do agree with Jiwon's suggestion to turn it to technologies. But on the other hand, for social media, it doesn't necessarily have to be cutting edge. We're very privileged in California, because we actually are on the cutting edge, but we were thinking about, different practitioners and different experience levels. And so we wanted to not have it be so, specific that it would shut out the majority of potential practitioners. Yeah, another reason why we have some of these technologies, so for example, NFT and blockchain, is that even though blockchain's been around for a while, the implementation has morphed several times. And I would say the same thing with social media platforms, commercialization, whereas before it was different. Anyway, so that's part of the the underlying foundational reasons why this list was created, and then also to just support what Paul was saying about the tension about keeping it updated, and then also agreeing with G1 about calling it technologies, and then having that other emerging technologies 4.15 to indicate that it would be potentially updated. Thank you.
Yeah, I fully agree, and yeah, I agree as well. With G1's suggestion to just keep technologies under Section 4, and then this resolve the issue. Yeah.
Hi, it's Mariah. I don't have a real insight into whether emerging technologies or technologies should be how this is titled, but from an organizational standpoint, is this outline supposed to reflect how the curriculum will be organized? And if so, I would recommend moving Section 4 down, because the other sections seem to be really foundational, right? Data collection, use, data security, and then I think that would kind of flow better into a discussion of emerging technologies, which are really the practical applications of some of these foundational concepts.
That makes sense in a structural, a structural sort of building organizational. I don't know if they're going to test in this order. By the way, I did want to also reiterate that emerging technologies as a term is a term of art, I guess, that is used across industries and in the government. So it's not that it literally means emerging technology like we're interpreting it. But if you do look up like the White House report on emerging technologies, emerging technologies and privacy, in different industry reports, they do refer to emerging technologies as a term, and then they will list or address these different topics. But anyways, yeah, I mean, if it's going to be, if the order impacts the test in any way, I don't think anyone's necessarily wedded to the numbering, right?
Yeah, I guess that would be kind of a question for the bar is, does the ordering here have any impact on the way things are tested, or?
It doesn't. No, it's just as a guide for what for our developers, so that I know what they should be drafting in, and then again for the applicants, so that they know that what kind of topics they can be tested on. The only one that has to stay the same is the Section 1, the PR. Yeah.
Thank you. All right, do we have, and I agree with Mariah as far as, if I was to structure things, I'd probably put this down at number 7 or something like that and bump other things up. If it has no impact, then I guess it doesn't really matter for our purposes. Any other comments on technologies as a section? Okay. Then we have a shorter one, use of personal information, which includes de-identification, pseudo-anonymization, aggregation, confidential information and business information, targeted advertising and marketing, and legitimate purpose and permissible use. Any comments about this topic? Okay. Next is data security. This one's a little bit longer. Here we have data security principles, confidentiality, integrity, and availability, encryption, information at rest and in transit, access control and identity management, MFA and role-based access controls, secure data lifecycle management, data collection, processing, storage, and destruction, retention and deletion policies, security audits and compliance assessments, regulatory frameworks requiring specific security measures, network and application security, firewalls, anti-malware tools, and application security testing, incident response and data breach management, notification requirements and stakeholder communication strategies and technologies for preventing data breaches, including intrusion detection systems, and security information and event management, physical security and environmental controls, and cybersecurity policies and governments. Any comments here? It is a pretty robust list there. Okay, hearing none, then we have data sharing with compliance with the law, PRA requests, law enforcement, data sharing with government agencies and reporting, service providers, contractors, and processors, other controllers or third parties, data monetization, data sharing for targeted advertising, sale of personal information, cross-context behavioral advertising, notice and transparency, consent for sharing, sensitive personal information, data brokers, and cross-border data transfer. Any comments here?
Just a quick comment on the previous section, section 6.
Okay.
Sorry for late response. I was just processing it. Should we note anything? I know we have instant response and data breach management, but should we note anything about what's it called? Forgot the proper terminology, but for emergency responses or disaster related stuff. I forgot, it's the ERAP plan or emergency response plan, something like that.
Like this disaster recovery type.
Yeah. That's my only comment for that section is whether or not, if it's in that section or another section, should we include that? That might be significant in terms, I know there's instant response, it's data breach management, but should we comment about natural disaster, or not natural, but disaster related responses?
I don't recall it being in another section.
It is, yeah, I see your point, Michael, and maybe I'm thinking about business continuity as well. We could put, those two together as a topic, maybe, but.
Yeah, and I like the call out. I'm wondering if data security is, I mean, you have availability under the CIA triad. I wonder if there's another section we ought to put it in. No, maybe not.
I mean, we could just think about putting it under 6.1 as a 6.1.2, even as broad as, administrative, technical, and physical controls, which would kind of cover, right? Those are principles that, I think could cover, disaster recovery and business continuity, but. But there are some specific, there's so many specific call outs. So I would be fine also with adding it to just as a separate item on the list too.
Yeah, me as well. Do you want to, if there are no objections, do we want to add a 6.1.2 disaster recovery?
And how Mira said, business continuity. Oh, that might be a separate thing, I'm not sure.
I think we want to keep in mind, these topics are meant to be privacy and cybersecurity issues, related to disaster recovery and business continuity, right? So there could obviously be other issues that are not related to data and cyber security functions, but I think privacy and cybersecurity technology lawyers do get involved in those business functions. So I would agree with adding those.
All right, thank you. Going back down to section 7, data sharing, any other comments on that one?
I just, data monetarization, should that be data monetization? Or am I not knowing what that term means?
I was thinking the same thing.
Okay.
Who worked on this section? Just to make sure that we are capturing the right edit there.
I think the intent is to be data monetization.
I would say that's data monetization.
Thank you. Yeah, that makes sense. Okay, and now moving to the section 8, where I think we'll probably have the most conversation here. We discussed just deleting this, but we wanted to bring it to the group before we did that. There is a lot of obviously privacy adjacent topics here. It's privacy adjacent topics. That's what the section is. But for, you know, we weren't sure that this is what we wanted to be raising to the bar as something to be testing our privacy lawyers on, because these are such big areas, like IP. You throw in that as a topic, are we going to get, 10 IP questions if we do that? Which you wouldn't expect if you're a privacy lawyer taking a privacy law test. That being said, there is a lot of value and overlap, and so we would appreciate the group's perspective on this. Smita, I see your hand is raised.
Yeah, I think some of these should stay like differential privacy enhancing technologies. I don't think you can practice privacy without knowing a little bit about what the tools are that can help you stay in compliance with those laws. That's what those are. So I think some of this should stay. Also, if you are advising on, let's say, AI at work, which I think a lot of privacy people are these days, if you don't know anything about the EU AI Act, that might be a little hard for you to be able to do that. So I know we've put under emerging technologies or whatever we're calling it, artificial intelligence. So maybe some of this can move up to a different category, but some of it should be discussed because it's not exactly that far out from the realm of what a privacy professional does. Similar with like M&A, a lot of first-year law firm associates in any group, including privacy. I was a first-year associate. Back at the time, we didn't have a privacy group, but I did both privacy diligence and tech diligence for all M&A. So it's actually a skill set you really need to pick up when you do start practicing privacy law. And so again, I think giving some basics of what privacy diligence is, or that the fact calling it out as being a thing is important.
Thank you. Other comments on keeping this or not?
So I fully agree with Speeder's comments on M&A, and yeah, I also had similar background as well when I started in a law firm. Having said that, not everyone goes through that. It has that has a background these days. So I think it's helpful to have it, but then I don't think M&A or due diligence should be overstated as well, because yeah, not every company goes through an acquisition or whatever, right? So it may not necessarily be something that everyone in the privacy space would be expected to have. I think it's a nice to have without being an expectation, I think.
That's exactly the debate, Paul, is, because this is meant to test expertise, right? And we talked about this at length during the last meeting, that this is not a test of competence. This is to certify that whoever has a certification from the State Bar of California is recognized as a leader in this space and an expert in this space. So if you are an expert who is recognized as being a privacy specialist, would we expect that they have some basic minimal understanding of what are the privacy issues, or would you be able to issue spot and work on M&A due diligence and post-merger integration issues? I think that's really the question, is what are the topics that we think are baseline for testing expertise, testing excellence, not competence, right?
No, in that case, I would keep due diligence, but I'm having some doubts about M&A, because you don't necessarily need to have an M&A background to do privacy. But then I do think that all organizations will need to sign contracts and so forth, so they need to understand the due diligence process. But then M&A would be something which it's nice to have, but then many companies will never even go through the M&A process.
I think the misunderstanding is happening about how deep we're going into any of these topics.
Yeah.
Because right now they're just headers. So I don't think anyone, at least we were not expecting it to be like a full-on course in M&A and how to draft a merger agreement and what the clauses are. That was not the intention. The intention was, when two companies merge, it's important to consider how their data is going to merge as well. And there are potential ramifications there in terms of laws. You might run into regulatory issues with the maybe an antitrust, depending on what these, and all of this is stuff that's like in the news. So again, I don't know if you could call yourself a privacy expert if you weren't able to issue spot something like that between two companies that are, maybe heavily invested in data.
Yeah, and this is Arson. One other point to raise is that there's actually a direct link with California's privacy law on this issue. For example, under the definition of sale under the CCPA, there's an exception for disclosures of personal information that happen in the M&A context. In addition, the CCPA was recently amended where the buyer essentially in an M&A deal would have to honor or opt out a sale request directed to sellers. So it's not just the industry specific issue. There's actually a direct link to the law and these issues related to M&A deals.
So Arsen, that's a really good point, and it actually kind of dovetails on what I was thinking, which is, I think if we drill down on a lot of these topics, they should actually be covered or touched on in the other categories. So for example, the degree to which a privacy specialist needs to understand the implications of privacy in M&A should be touched on, in my opinion, in the data sharing and component. So it's hard because we don't have subparts to these high level topics.
Yeah.
But I would not be in favor, like, to me, when I look at 8, it's just unwieldy. And it would be challenging, I think, for a practitioner or an applicant to even really get their handle on, well, what exactly is required of me here. I think what we might want to do is take a closer look at these component parts and just make ourselves confident that they're followed, that they're likely touched on in other ways. So dark patterns, auto renewals, online tracking tech. A lot of that is going to be like cross-contextual behavioral advertising. Just there's some obvious ones that I think we can probably pick off.
Yeah, I would agree with Mariah, and I think this is where I think Ryan was proposing, is that this is so if we remove certain of these topics from the intersection, chapter 8, it does not mean that we don't think it's important, right? It's really this is really an exercise, I think, to present a list of exam topics. So, to your point, Samantha, maybe not everyone is an M&A expert, but let's say that there is a specialty CLE all-day seminar that somebody wants to offer, and maybe somebody wants to take 8 hours of CLE on M&A due diligence and privacy, and that would be fine, right? So, I think I think what we want to do is, if we want to remove section 8, are all of these privacy adjacent topics included already elsewhere, right? Is that good enough? So let's say for, data sharing, the concept of privacy due diligence, could that show up, let's say, in data sharing with controllers? There is data sharing with other controllers or third parties.
Yeah, I think we're all on the same page. That's what I was saying at the beginning, is that AI is already called out somewhere else, so we should just move stuff to other places. Yeah, we're all on the same page. I agree.
Yeah.
I'm just saying the topic should be covered. Like, I don't probably maybe covered in other buckets already. So let's just let's just bring
I
it
don't know
up.
if has anyone said that we want to keep, I think that would really, the question is, if we just kept 1 to 7, are the topics broad enough, but give enough, color to what these exam topics are, so that the topics that we think could be basis for an exam question would be included. So, if we got rid of 8.1 to 8.9, are they covered in the previous sections? And if they're not, then we can add it, right? We can add it to the previous sections.
Right. Are there any that we want to bring up as specific call outs to ensure that they're on the test?
That's right. As a specific exam topic, because I think they are really meant to be high level, right? We don't want to have to change. We want this to withstand the test of time. So without having to change in the next, hopefully, at least 2 years, are these exam topics broad enough but specific enough?
I personally think that all of these topics are covered broadly in the categories that we've already looked at. I think to the extent that, just looking through everything here, I was thinking about UDAP and Section 5 of the FTC Act is so fundamental, right, to privacy practice. But I think the intent is that we're trying to stay away from calling out specific laws. I think that's another piece of this, is that there's the topics, but I think if you look at everything above, we've sort of taken out references to specific laws, knowing that the exam could cover those, but just wanting to have this stand the test of time, it's described a bit more broadly.
I agree.
I would agree as well. I think a lot of these laws, for example, really could be phrased as like consumer protection. And then a lot of these would fit under the technology section, or could be covered there.
Right. I think we already have AI on that. So that would encompass AI ethics, just going down the list here, AI regulations, EU AI Act. I think the NIST risk management framework, that's already in the security section above. I don't think we have IP, so I don't know if we want to flag that one. Or does the group think that maybe IP doesn't need its own call out? That's okay too.
Do you want to
Advertising.
speak to it?
Sorry, Jawan.
I think Smita had some comments about how IP intersects with privacy.
Yeah, that was back when we wanted to have an intersection topic. If we don't need it. It's fine. I think the assignment earlier that we were given was that we want to call out an entire intersection topic, which is why we put antitrust and IP as things that coincide with privacy. But if we are limiting it just to privacy, then let's take it out. It's fine.
I think what we want to capture is what are the privacy issues that intersect with IP, right? And what are the privacy issues that intersect with antitrust and unfair competition, like Lindsay was saying, UDAP and UCL. So
yeah, I think some of those might be, again, like when we write it out, right? Like when someone makes the curriculum, it could be called out in like an AI, subsection. Data sharing could call out antitrust.
Yeah.
So there are options, to be creative.
I think so. So you're okay. You're okay with removing IP?
Sure.
Maybe the one thing that I feel like I'm not sure is covered as specifically as we might want it to be is the advertising and marketing. Just because it's not really listed as a technology, it's definitely falls under sharing, but it's such a big part of, I think, what we all deal with, so maybe looking at whether that is, but it's under cross-contextual behavioral advertising, and targeting, never mind, it's there.
It's also up in section 5, targeted advertising and marketing.
Perfect. Yep.
Oh, we have targeted advertising in 2 different places. Maybe we should not do that.
We missed one.
You're right. Yeah, we have it in 5 and in 3. It's because it's a collection issue and also a use issue.
And it's in
do we
7.
want to?
It's in
It's in
7
7
also.
too?
Yeah.
It's everywhere. You're right. I see target. Oh my goodness, we got target advertising and behavior advertising. It is everywhere. Do we, to the extent that it's really everywhere, it's sharing and use and collection, do we want to put it on? I think the thought was, I don't think this is just about ad tech. I think there is advertising, right? And then ad tech too. But I could see ad tech being, under technologies, and then all of the issues, substantive issues with ad tech would fall under there if you want to remove it from all the different functions. But I feel like ad tech doesn't quite capture all the other privacy related issues.
Yeah, I'm not sure we need to have it everywhere because it is a bit confusing as well for the reader when they're trying to prepare for this, understanding what exactly do they need to know if it's everywhere, right? So, yeah, if we could limit it only to some sections, I think that would be preferable.
Yeah.
When I look at maybe centering it in one area, maybe it's use, because that does describe things a little bit broadly. I mean, I know that we can talk about collection and sharing, right? But if we talk about use, maybe it's sort of it's centered there, grounded in one area.
Yeah, I agree.
So remove all references to targeted advertising and marketing except for section 5. Would that be your proposal?
That's my proposal. Yeah. I don't know if others agree.
So that would be 3.5, Ryan, and 7, and so we're keeping 5.3, and in 7 that would be 751 and 753.
Yeah.
Is that it? Are those all the references for marketing and advertising?
If we get rid of 8.
If we get rid of 8, That makes sense to me. I do think that we were really kind of trying to think about business events and, privacy issues related. I did not catch that marketing ended up in, 4 different places. So thanks for that catch. I think Ryan and I did not catch that when we were trying to, consolidate. I would be okay with moving it to section 5, as Lindsay suggested.
Agree.
I agree with that.
Is there anything else in section 8 that we would like to call out specifically and move up to one of the other categories?
Content moderation and free speech a little bit different? Or would you still say use of personal information that covers it?
I think it's covered in use.
You think so?
When I had, conceived of it before. At least the First Amendment. I guess content moderation could be viewed differently.
Do we want to make it a 5.5, just so that we call it out? Or do you think this is broad enough? We don't need to call it out.
I'm personally open to calling it out because I think it's only going to increase in significance.
I would agree with that. Because I just don't know if, if people are, because I'm thinking about this is a text that's going to outlive us, right? And so, I don't know that people would know necessarily that we were thinking about content moderation falling under use. They might be its own thing.
I vote to call it out.
Works for me. It's like we already have notice and transparency in 7.6.
Oh, yeah, you're right. We got notice and transparency in 2 different places. We have 2.1, so we can remove, I think, 7.6.
Yeah. And then online tracking technology, I don't see that elsewhere. To me, that seems like something that could be a call out under technologies.
Yeah, I think we didn't do ad tech. Do we want to call out ad tech as a technology issue?
I think that makes sense. If we've got health tech and fintech, I feel like ad tech is probably something we should have on the list. Technologies.
Yeah.
Janelle, and team, once we finalize our work here today and we vote on the substance, do we have, are we allowed to do some, stylistic changes, like changing around the order and things like that, as long as the substance is the same between now and presentation to BLS? Or do we have to kind of finalize, like, this is the copy that's going to go to BLS?
This will be the copy that goes to the CBLS
Okay.
once you vote on
So
it.
we can't even make changes to the order that it appears.
You can maybe designate as part of the approval, maybe designate 2 people to do a final review um
Okay.
and to finalize the
Mm,
actually finalize it before going to the CBLS.
okay. Yeah, I would propose for that, just so that it's readable. Like, I don't know if we want to make this alphabetical, like those kinds of things, right? Do we want to make it so that it makes sense in terms of chronology and whether we want to alphabetize, et cetera?
Yeah, I think we could clean it up just a little bit. Anything else as far as section 8 that the group would like to call out specifically?
So did you, and I just saw online tracking technologies in 3111. Is that still in there? It is. So if we added ad tech, do we remove that from here, just so that it's not repetitive? Or do we want to keep it because the collection issues with online tracking technologies are different?
I could see ad tech being more comprehensive than obviously online tracking technologies, and also being a little bit more like industry oriented, and thus justifying its place in both.
So you would vote to keep 3111?
I would vote to keep 3111 because it is such a critical component of how data collection occurs online. But I would also vote to keep ad tech as its own technology subset. And there I envision just a discussion of like the ad tech ecosystem, which goes beyond just how things are collected online.
I'm good with that.
I agree.
Sarah, I'm getting nitpicky. Is there a typo? 131, attorneys' use of AI, is that still in there? Is there supposed to be an apostrophe? Okay, thank you. So I see those 2 things are AI. We do want to call those out rather than just having AI as a technology.
I think that one's in the PR space,
Right.
so it seems like very like firm oriented as
It's
opposed
specific,
to
yeah. Those are specific things. Can I ask another procedural question, Janelle? Let's say we assigned 2 people to do the cleanup, and we do the BLS. If BLS approves and it goes to the Board of Trustees, is there another process to make any changes between BLS and Board of Trustees, or is that the final copy and
That
no
will
more
be-
changes can be made? No more
That
changes
will
can
be
be
the
made after
final
that?
copy.
Okay.
Well, what if we got recommendations from the CBLS for some changes?
So I was going to be spoke about in the next step. If recommendations are required from the CBLS, we will have to come back and have another meeting to discuss those changes with the group.
I see.
So that would be another opportunity for editing.
Yes, if the CBLS does not approve this
As
proposal.
is. So we
Mhm.
cannot accept any changes at the BLS level. If there are any recommendations, it comes back to us to
Correct.
discuss. Got it. Just doing a quick time check for you, Ryan.
Yeah, it's 11. I know we have some folks who will need to drop off, so all right, any other section 8 considerations or any other comments generally about the list? If we have none and we're happy with the way it looks, I'd like to call for a motion to approve.
Could I make a motion to approve with the added proposal that we will assign 2 people to make any final touches? You know, looking up typos, trying and you know if and fixing the order in which it appears before this is prepared and presented to the BLS.
Can we add the names to the nomination to
Oh,
the motion? Sorry.
sure. Is that I think we discussed Ryan, Lindsay, and I doing the presentation at the BLS. I don't know, Ryan and Lindsay. Do you want to do it? Do you want me to do what? Who would you like to work on doing the cleanup?
I'm happy to volunteer for some cleanup.
Yeah, me too. You know, that works.
Okay.
This won't be too much of a lift, so.
All right.
Please do
I
remember
will-
the Bagley Keene that only 2 people are able to work on something with the back of the daisy chain.
Exactly. So I think I am making a motion for Ryan and Lindsay to do the cleanup to prepare the final copy to go to BLS.
Second motion.
Okay, and I believe we will vote by roll call.
Ryan,
Approved.
Soleil, Serrato,
Approve?
Martinez,
Approved.
Krolik,
Approved.
Isri,
Approve.
Jaworski,
Approve.
Munaka,
Yes.
Lenoy,
Moved.
Kirshenson,
Approved.
Davis,
Approved.
Rajmahan,
Approved.
Choi,
Approved.
with 14 yeses and 0 no's, the motion passes.
Awesome. So we will now be moving on to item 3.2, which Lindsay will present. This is discussion and action of the proposed task and experience requirements for certification and recertification in privacy law. So I'm going to now turn it over to Lindsay.
Okay, thanks, Ryan. So what we have done is, as a reminder, we looked at tasks and experience requirements in as a group. We looked at a few different areas. If you remember, we pulled it into 4 different areas. And we talked about whether that made sense, and we saw a lot of overlap, kind of in some ways similar to the discussion that we and the exercise that we just went through about the exam topics. So Jawan and I pulled together a consolidated list, and we have put it into this format, which the staff has given us as there's examples from the other specialization areas that follow a similar kind of construct. They're all a little bit different. And the one that we felt was most true to the discussion that we had as a group in our last meeting was the specialization related to the franchise specialty. And that's what you'll see. This sort of follows this format. So I know this may be a little bit of a new format to some of you. So I'll kind of walk through what it looks like. It does this attachment A, and invite the staff to jump in here, is something that would be a part of the applicant's application. And so they're going to fill out this form. It starts with this requirement that the 5 years preceding the application, they need to be involved in these tasks and experiences. And then the construct here is that there's flexibility in these tasks and experiences where the applicant needs to get to this 100 points. So, and you'll see the list in a bit, and there are maximums per task, and people can pick and choose for what fits their experience, because as we've discussed, people who work in privacy have such varied backgrounds and experiences. So we wanted this to reflect that, and so that people with expertise in privacy could get to the 100 points in the way that makes most sense for their background. Importantly, each task can only be counted in one category, so you can't double dip. And then there is a requirement that for every section where someone is claiming 20 or more points, they need to provide a brief narrative statement about that experience. And there's a request here to keep everything confidential. So the different areas are below, and there are, let me see, I'm scrolling fast, I'll go back up though, but there are 15 total tasks and experiences. So I will go through them. And these are not in necessarily any particular order. 2.1 is providing substantive written legal advice or analysis regarding regulatory compliance with privacy laws. 5 points per matter, and the maximum number of points in this category can equal 35. And as I've mentioned, we sort of base this off of the franchise specialty example, which we felt like had both sort of transactional and litigation elements and these point constructs. 2.2 has to do with data privacy terms and contracts. 2.3 has to do with data sharing requests or counseling on cross-border data transfers. 2.4 involves privacy due diligence involved in corporate transactions, including M&A, etc. 2.5 is advising on policies, procedures, or processes relating to security, basically, physical, technical, and administrative privacy and information security controls. There are a few here on litigation, and I'll talk about that in a little bit more specifically, because you'll notice that there is a maximum category of points in this category that is 65, as opposed to 35 in most of the more transactional elements. And we wanted to reflect that that often privacy attorneys involved in litigation or where litigation is their major practice, they might not be able to get points from these other areas. So we allowed for this sort of additional points based on the number of hours spent on the litigation. So 2.6 has to do with representing a party in litigation on privacy issues. 2.7 is similar, but having to do with representing a party in a government investigation around privacy law matters. And then we have a couple of additional areas in 2.8 and 2.9. Oh, sorry, it's, yeah. Yes, 2.8 and 2.9 that relate to pre-litigation and maybe post-litigation. So 2.8 has to do with devising and implementing the litigation strategy in connection with pending or threatened litigation around privacy law. And that is a maximum number of points of 35. And 2.9 is post-litigation, basically. So devising and implementing a formal compliance program for a client following the entry of a court order, consent order, settlement, or other award in a litigation or investigation around privacy law. So if you kind of do the math on that, if you were an attorney that is solely engaged in litigation, 65 plus 35 is going to get to 100 points is the idea there. 2.10 has to do with data inventory or record of processing activities. 2.11 has to do with developing external facing privacy notices or statements. 2.12 is on analysis or advice for privacy issues for marketing, product, feature, or service delivery, including privacy impact assessments. 2.13 is relating to data subject or consumer rights requests. 2.14 is around incident response or data breach investigations. And 2.15 has to do with breach notifications to regulators or affected individuals. So I will stop there and see what comments or questions people have on this construct and on the list.
If there are no questions, maybe Lindsay, I can provide a little bit more context into how we assigned the different numbers and some of the framework for the task and experiences. We took into consideration the tasks and experiences that the consulting group had worked on during the last two meetings. And then saw, at the request of the state bar, how the other specialization organizes it into the actual attachment A here, which will be part of the application. And we did not want to make it overly complicated, so we chose a number 100 because we thought that would be a good, number that's kind of easy to remember and easy to divide up. We also took into consideration some of the group's comments during the last meetings where we talked a lot about, is there a certain minimum areas of expertise? So what if somebody is just a litigator? What if somebody is just an M&A, due diligence person? What if somebody is just advisory? So we really try to take a look at, if somebody were to be an expert, would you be able to get to 100 points? So we wanted to be fair in terms of being able to assess expertise. And if you were very much an expert in one area, let's say litigation, for example, you could get up to 65 points because you're doing a lot of them. So it's really the volume and the intensity of the work. But if you were also doing a little bit of everything, you were a generalist, then you can also, hit maybe 5 or 6 or 7 of these areas, other than just one. So that was really the thinking, that we kind of try to make this a fair way of assessing, and so that, whether you are a generalist or you are very specialized in 1 or 2 areas, that you will be able to get to 100 points. That's really the thinking behind the numbering. Does anyone have any questions or comments?
So this is initially upon earning your specialization, and then there's a renewal, correct? And how frequently do we have to, or is it the same requirement for the renewal, and how frequently is that?
Good question. I believe this is initially for the certification too, right, Janelle?
So this will be for the initial certification once they pass the exam. and as well as to recertify every 5 years
Mhm,
upon initial certification.
mhm. So in order for, even if somebody were to obtain the certification, if you're not able to continue at this level, you will lose the certification, in 5 years. Right? If you're not able to meet the recertification standards.
Correct.
Does it mean that someone who's making an application must count how many legal opinions written, for example, in relation to regulatory compliance with privacy laws and so forth, or how does it work?
I believe this is the form that you would fill out. So I think, you would say this is the number of matters, and each of the standards has the number of points that you will get per matter. So let's say for 2.1, you have 2 matters, you'll get 10 points. So you would put 2 in the number of matters, and you would put 10 in the number of points. You add up the number of points claimed, and you would have to get to 100.
Okay.
And I think the intention, right, is that, the maximum number of points in these categories, it works so that there does have to be some breadth, as well as depth. So just kind of taking that into consideration.
Yeah, I think there are also 2 other, it's got nuance into this point system. So we have to come up with some kind of a quantitative way, right, to assess it. But I think there are some qualitative, aspect to this too. If you look at the note at the top of that chart, if you are claiming more than 20 points in any of these sections, we're asking for a narrative statement. So you would have to describe, how significant those matters were. So that's, one kind of qualitative check to the quantitative nature of this assessment. And then at the end, we also say, if you're unable to meet any of the requirements above, and you can submit other experience demonstrating substantial compliance. So that does allow for, I think, some consideration of other narrative statements, if a particular person would like to challenge and say that, my experience doesn't quite, neatly fit under these standard sections. I think those are our checks that Lindsay and I have added to allow for exceptions.
This is Michael. I'm just checking the alternatives. Seems good that you provide an alternative as well, because not everybody will neatly fall into these categories. I'm not sure if it encompasses, say, a professor or other individuals who are teaching or any of the substantive stuff as such, but I'm just trying to parse the language to see if that's covered at all.
Yeah, and
Does that
Jawan and I discussed that, and I think part of our understanding is there's a continuing legal education requirement as well, which, if you teach a class, you're going to get tons of continuing legal education, actually, and that could count for that. And I think the intention of this specialty is for lawyers who are practicing. So if you are not, if you're only teaching and not practicing, then you would not pursue this specialty. And my understanding is that's, the intention of these specialties is to be really for practicing attorneys.
So to the extent that like Lindsay, who is teaching, she is a professor, but she is also practicing and she consults, then Lindsay would be able to meet some of these requirements. Any other questions or comments? It's a good question, Mike. Lindsay and I spent several meetings and talking through all the different scenarios. We took into consideration someone who is in a law firm, who is a solo, who is in-house, who is in government, who is in academia. We really kind of try to think about all the different permutations, of where privacy specialists may be practicing, and try to kind of run through the numbers to see if we can get to 100.
Well, hearing no other questions or comments, it looks like we can move to a motion. Do we have a motion for moving forward with item 3.2?
Yanaka here, and I move to accept item 3.2.
I second.
Karanian,
Approved.
Soleil, Serrato,
Approve.
Martinez,
Approve.
Krolik,
Approve.
Isri,
Approve.
Jaworski,
Approved.
Naka,
I vote yes to approve.
Lanoy,
Approved.
Hershenson,
Approved.
Davis,
Approve.
Rajmohan, Choi.
Approve.
With 12 yeses and 0 noes, the motion passes.
Wonderful.
All right.
So
I think I
we will-
have, oh, go ahead.
Oh, no, I was going to say we'll now move to item 3.3, which Jawan will present.
Yeah, I was gonna say, have you been screen sharing? So I'm sharing my screen now, or, oh, okay, great. Thank you. All right, so this is item 3.3, and we're going to be discussing the proposed continuing legal education topics. And so this should look pretty similar to the list that we discussed last time. What we try to do was we try to, again, do some cleanup and have it match some of the discussions that we've had on the exam topics. So we did discuss, should the continuing legal education topics match exactly the section headings from the exam topics? And we ended up not. So, and I think one of the major reasons for that is because the way that the continuing legal education topics were presented to us in our previous meetings, they were not, 100% matching. And I think the feedback from the group is that it didn't need to. So we kept the group's interest and the comments from the last. And so this is substantially similar, I would say, to the list that we had before. But there are some minor edits that we made. I think mainly, probably one of the biggest changes that we're proposing here is to remove specific laws, which we did discuss. So during the last meeting, we discussed, not having the exact laws, but describing the particular principles or themes. And so this is the list of topics that I believe were presented during the last discussion, minus the specific laws that were added as examples. Do we have any questions or comments? So again, just reminding us, what are we looking at? This is the high level set of topics from which continuing legal education can be offered. And continuing with CLE and in the privacy specialty is going to be required for the application itself, but also for the recertification too. So we want these topics to be broad enough. We want this to cover the exam topics. Because those are the topics that we think are relevant to assessing expertise in this area. But we also want this to be able to be flexible enough to include future topics. Because again, we're expecting that we will not be able to make any changes to this, at least for a few years. So that's really the lens with which we're looking at this, broad enough and flexible enough. But specific enough to cover the exam specifications that we just approved.
And you already mentioned this, but I think that there has to be some flexibility here too, because education topics change. There might be new needs in the future. So yeah, I just want to highlight that because I think that's something we do with a lot of the legal education requirements.
Yeah. I mean, is there like a catch-all that we can add, because, Amy, I think you would empathize with us that this is probably a legal area. We think it's an area that is changing, maybe even faster than some of the other specialty areas. So I think the list that we are proposing today here is pretty broad, but, do some of the other sections add something like emerging legal issues in privacy or something like that? Should we really kind of try to make it so that if some emerging privacy legal issue is not covered, that it allows for that flexibility? Is that something that you recommend?
Yeah, I might do that at the end like you did with the other. And I know emerging and recent that was it took some time to get through, but I think it might be helpful here, like maybe add it there like other emerging topics in the field or something like
Okay.
that.
So
Just
that
to
would
note,
not be okay.
yeah, just to note that that some flexibility will be required. It will be required in this field.
I like that. Other emerging topics in particular. Yeah, perfect. What does everyone think? I like that suggestion.
I like this list. I think it's pretty comprehensive, and having that flexibility is very helpful.
I agree.
Anyone have any comments? Questions? Okay. If we don't have any more comments or questions, do we have a motion to approve?
A motion.
Ryan makes the motion. Do we have a second?
Second.
Thank you, Jesus. Janelle, should we do roll call, please?
Kalanian,
Approved.
Calais,
Approve.
Serrato,
Approve.
Martinez,
Approved.
Krolik,
Approved.
Idris,
Approve.
Jaworski,
Approved.
Unaka,
Yes to approve.
Lanoy,
Approved.
Hershenson,
Approved.
Davis,
Approved.
Rajmohan, and Choi.
Approved.
With 12 yeses and 0 noes, the motion passes.
Okay, so we will now move to item 3.5, 4, which Jawan will present as well. Discussion and action of the proposed alternative to the exam requirement in privacy law.
Thank you, Ryan. So to remind the group, what this means is that once we have the Board of Trustees approval, the specialization application process will begin. So we could have a specialist application even before the exam is approved and goes live. So to allow for the time, because we anticipate some time will be needed to prepare the exam, the State Bar of California routinely allows for an alternative to exam in the first 2 years, I believe. So for the first 2 years after the Board of Trustees has approved a new specialty, this will only be for that first 2 years. It will never be used again. To the extent that a new legal specialty has been approved, but no exam exists yet, this will be the alternative to exam standards. And we looked at and we discussed during the last presentation how it's going to be a plus, right? So instead of 100 points, let's say, in the task and experiences, we're proposing to ask for 150. Because again, this is really meant to allow for the specialization to be accepted for somebody who has gone above and beyond. That it really, we don't even need an exam for this person because this person is just very much top of the field and can really meet all of the different standards that we have approved today. So that's the 150. And so while the regular person who is taking the exam can show by passing the exam that certain knowledge has been acquired and you have a certain expertise, this person will be showing by additional tasks and experiences. So even more broader, I think experience is really what we're looking for, is that, in order to get 150 points, because we have each of the standards limited to, most of the time 35 per section or 65%. This really would, I think, give advantage to somebody who has more of a broader practice, and we acknowledge that. We think that for somebody to obtain the certification without having taken the test, that you would need to show breadth of experience. So that's number one. Number two is additional 15 hours. And Janelle and Adrian, please explain this to me again. I know that we discussed it, but we are going. So this would be in addition to the application, right? So to be able to apply and have the eligibility to apply, you would have had to done a certain number of CLE to have evidence have done privacy CLE. And this would require 15 hours in addition to the minimum eligibility. Is that right?
If I'm not mistaken, this will take over the certification application because they have not passed the exam. No, am I correct, Adrian? Sorry, go ahead, Adrian. You're on mute, Adrian.
Can you repeat the question just so I can?
Yeah, so I wanted to basically understand, because I think our understanding was that this would be, so there is a set of eligibility application. There's an application and then there is the alternative exam. And so I think the 15 hours is supposed to be in addition to the
45. Yeah.
The 45. Thank you.
So this only replaces the exam requirement. So you're right. So applicants will have to still submit the initial application. And then this is going to be essentially on top of that.
That's exactly what I thought. So thanks for confirming that. So there's an initial application and then there is an exam. And this would make it so that you're not taking the exam. And so since you're not taking the exam, we would basically require that you have done 60 hours of CLE. Again, this is a plus requirement, right? So you don't just have 45, which is going to be required of all applicants. You're going to have to demonstrate that you have 60 CLE hours in privacy law. Within the 5 years preceding the end of the 2-year alternative exam period. We wanted to also highlight that for you. And I believe this is how it's done in all of the other legal specialties. So we did not change. This is how all of the legal specialty exam requirements or alternative exam requirements are done at the state bar. So what that means is the CLE requirement is 5 years preceding the end of the 2-year alternative exam period. So let's say next year the Board of Trustees approves and the legal specialty is now open. The application process is open. It would be that it's until 2027, right? So 2-year period would be from 2025 to 2027, and it would be the 5 years preceding that. So it would be from 2022 to 2027. Meaning if you have not done the requisite number of CLEs, you have 2 years. You have 2 years to complete those. Did I capture that right, Adrian?
Yeah, so the task and experience is in the 5 years preceding, but the education's 3 years.
Oh, so we need to change
Unless
it
you're
to 3,
saying
not
for
5?
yeah, unless you're saying for the education that for the alternative you're gonna say 5 years.
I think we meant to do what the other legal specialty is doing. I thought it was 5, so I'm sorry if we got that wrong. So this is 3 years preceding the end. So meaning so if the specialty is approved next year, the 2-year will end in 2027. So that would be now. So from 2024 to 2027. You would need to have shown 15 hours of privacy CLE. Is that right?
Plus the 45, yeah.
Plus the 45, yeah. But for these extra 15 hours that we're going to request, it would have to have been done between 2024 and 2027.
The 45 should be 2, just to be that.
45 too.
Yeah.
So it's in the 3 years preceding the end of the 2 years. So basically what that means is if you want to become, certified as a privacy law specialist in California, once this process is approved next year, from 2024 to 2027, those are the 3 years, you would have had to have done 60 hours total. Did I get that right? So 45 for the initial application eligibility and the 15 hours plus because you're not taking the exam.
Yeah.
Can you also explain to me, because I know that you've talked about this, but I know that it's a little bit fuzzy for me. So you could apply to be certified and then still show and demonstrate the CLEs. Is that right? So you could apply next year as soon as, if you have the testing experiences and you meet the eligibility requirement and references and whatnot, and then still be completing the rest of the CLE requirement. Is that right? Or are we making it so that everything has to be in the package before you can apply?
It's faster if everything's already done, but technically, so if an application is submitted incomplete, it doesn't automatically, we don't automatically deny or disqualify the applicant. We'll reach out to them, let them know what's missing or if we need additional information, and then we'll give them additional time to return it back to us.
Got it. But as long as this CLE requirement is not met, you cannot say that you have the certification, right?
No, yeah, your application won't be approved if it's not complete.
Got it. So you are an applicant at that point, but you do have, so you could start the application process as long as you meet all of the requirements before the exam period.
Yeah.
Okay. Mike? I think you're on mute.
Hi, can you hear me now? Yeah.
Yes.
Sorry, I have a physical mute. For a quick clarification, if we do, you mentioned 2024 to 2027, but realistically, this is not gonna be passing till probably next year. So won't that be 2025 to 2028 when it passes?
It's 3 years prior to the 2-year period, so that's why it kicks it back
Okay.
this year.
Well, it's 3 years from the preceding the date of the submission of your application. So if you submit your
Okay,
application in January 1st of 2026, you can only count courses from 2023 to 2026.
got it.
Yeah, if you have submitted December 31, 2027, you would count courses from December 31, 2024 up to December 31, 2027.
Oh,
But
so it's
wanna
3
be
years prior to the time of application.
Yes.
What we have
Should
here
we
is,
change that in number two then? Because I think
yeah.
we had said that this is the 3 years, to the exam period. So it's
Yeah,
3 years
but
prior to the application.
so that 2-year period is going to end on, let's say it's approved on January 1st, 2025, the 2-year period would end on January 1st, 2027. So
Right.
it's really going to be,
It's one and the same, basically, right? If you don't finish the CLA, basically, any alternative exam requirements must be met, including the CLA requirement, within the 2 years
Yeah.
of alternative exam period. I think that's why we had it pegged to the 3 years preceding the alternative exam period, because that's the longest you could have, right? If you apply on the first day that the specialty is approved, then you have the full 3 years. But if you apply, let's say the specialty is approved next year, and you apply in 2026, you have less, right? You have less than 2 years to complete the application. So I think we meant to. I would say, is it Ryan or Lindsay with the pen? I think to go back, I think the reason that we had it end of the 2-year alternative exam period, because that is the longest somebody will have. And then could you also explain the third part again? So I understand the initial application is also going to have a peer reference requirement, right? And so this would be, again, outside of the initial application references that will be needed, you will need 5 additional references, again, making it that much harder since you are skipping the test requirement. Is that right, Adrian? And can you remind us again how many references are needed in the initial application?
it's 3.
3. So what we are proposing is 8 total. So in order to receive the certification in privacy law without having taken the exam, which will only apply for the first 2 years that the specialty has been approved, you will need to supply 8 references. Any questions or comments on 1, 2, or 3? Is everyone okay with moving the CLE from a 5 to a 3? And I don't know if we can. Can we deviate and give more time for the CLE, or we think we acknowledge that 60 is a lot. 60 hours is a lot because it is absolutely above and beyond what a licensee, a California licensee would have done. So clearly, we are really asking for somebody who is going above and beyond an average licensee, but can we give more time and say 5? Is that even an option, or is this just 3?
It's up to you. It's the
It's
alternative.
up to us. Okay,
The
all right.
45 will have to stay the 3, but if you wanted
Right.
to give them an extra 2 years for the additional 15, that's up to you.
We could. Okay, so that is up to us. All right. So I think for the group to discuss, provide comments, or approve would be, do we agree 150 points instead of 100? Oh my goodness. Should we clarify here that it's not 150 plus 100, right? Should we? I don't think we meant, that you need to supply 250 points, right, Lindsay?
Yeah, I think it says a total.
Yeah.
But
so is that
but
clear,
it might be a little
Adrian?
bit confusing because some of them are additive and some of them are not. So,
Yeah. So the intent here is not to require 250 in attachment A. The intent is to require at least 150 points total during the initial application process and in the alternative exam. Is that clear, Adrian and Janelle, or can we do something else to make that clearer?
Clear to me.
It's clear to you?
But for
Okay.
number 2, I would say supply evidence of at least 15 additional
Yeah.
hours.
Okay.
Additional would clarify that.
Yeah.
Mhm. Okay, so the first one does not say additional 150 points. Second will say additional. Yep, that makes sense to me.
There you go.
Okay. So with those changes, does everyone agree that this is the standard that we would place for somebody who wants to be approved as a specialist without having taken the exam in the first 2 years that the specialty has become available? Any other questions or comments?
Can I just clarify one thing, Jiwon? So what this means then is that this is a valid path for a specialization in the first 2 years, but once exams developed, assuming it's done in the first 2 years, this will policy will no longer be the case. Everyone will have to take the exam.
That's correct. That's my understanding, but you're bringing up a really good point, Amy. What happens if we are not able to? I have to always think about the worst case scenario, right? So if we're given 2 years to create the exam, is there ever a scenario where the exam is not developed? And then what happens? Do we just not have alternative exam and therefore we will basically suspend the specialty? Is that what happens?
You may have to ask for like a waiver and exception to the rule to
I
it's state bar rule. So
The 2 year
yeah.
alternative exam period? Got it. So if this is a if, and probably and hopefully it will not happen, but if we are not able to create the exam in the first 2 years, then we could extend this so that the alternative exam is available until the exam it becomes available. I'm going to assume that you don't have any precedent for that. It's not something that you're worried about.
No, I think our latest was I think it was Admiralty, and I don't think it went beyond those 2 years.
Okay.
But none of us were here at that time. So and it's a small field. But yeah, I think we will just have to in the event that the exam's not ready in 2 years, then we'll just have to seek a waiver.
Got it. Okay.
Continue.
We're just thinking through all the contingencies.
Yes. That's good.
Okay, that makes sense to me. It sounds like this it should not be a problem, and if it is, then we can deal with it there. I know that we talked about this in the beginning of the process. Admiralty was the last time. How long ago was that was created as a new specialty?
We'll take a couple minutes to look it up. Give me.
Thank you. Yeah, because I believe I think I had heard that it has been decades. Is that right, Adrian? At least 10 years, or maybe 20 years since the last time the State Bar has created a specialty. So this is very exciting. Any other questions or comments on the proposed alternative to exam requirement? If we don't, do we have a motion to approve?
So moved.
Thank you, Mariah. Do we have a second? Was it Hillary?
Yes.
Thank you, Hillary. Janelle, could we have roll call, please?
Karanian,
Approved.
Slay,
Approved.
Dorado,
Approve.
Martinez,
Approved.
Krolik,
Approved.
Idri,
Approved.
Jaworski,
Approved.
Yanaka,
I vote yes to approve.
Hanoi,
Approved.
Hershenson,
Approved.
Davis,
Sorry, approved.
thank you. Rajmohan, absent. Choi,
Approved.
With 12 yeses and 0 no's, the motion passes.
Thank you.
And to answer your question, sorry, Ryan, the last area that was done was in 2008, which is Admiralty.
2008, okay.
So we are now moving to item 3.5. I guess the one thing I wanted to ask was we are getting close to noon and potentially lunch. We could move through, or we could get ready to take a break, depending on how the group wants to approach this.
Yeah, I was going to ask about that too. We've been going for 2 hours now. So I think, you know, at least a quick break might be helpful, but we only have one more substantive presentation. So I don't think it'll take too long, and then it's just next steps. And I wanted to ask just, you know, on a technical note, the next discussion 3.5, the proposed standards, it really is a summary of everything. And so we made some changes. So do we have time to make those changes if we get a break and into the 3.5, or are we discussing the materials that were presented at the beginning of the meeting?
They're already made, Juwan.
So we will be discussing the changes that that we approved today. Okay, great. If that's true, I think this will be very quick.
Oliver, you had a comment?
No, Jawan's last comment just answered it for me. Thank you.
Okay, so would we like to do a bio break or 30 minutes for lunch?
I think we should go right through if what I'm hearing is we don't have a ton left on the agenda.
Agreed.
Agree.
Not even a break? Not even a 15-minute break? Mariah's ready to go.
Let's power through.
Yeah, we agree with Mariah.
Agreed. Yeah, let's power through.
Okay,
All right, well then we'll move on to 3.5.
awesome. So Lindsay, you made the changes already that we approved during today's discussions in the standards?
Yes.
Awesome. So just to present what this is the standards for certification and recertification in privacy law. And this will be the final presentation that we provide to the BLS once this is approved by the privacy law group. And this is basically a restatement of all of the requirements that we just discussed and approved. So thank you, Lindsay, for making the changes along the way. So there is no new content here, except if you can zero in onto the definition, because that is new. This is what the standards require. So Lindsay and I took a stab at describing, you know, what the privacy law certification does. And so this is new text. So I think if we spend any time, you know, discussing it, it really should be about, do we agree? Did we capture what this privacy law specialty is about? The rest of the material, I'm looking at the copy, I believe is exactly the same. If we were correct in capturing all the changes, I'm sure Lindsay has. It's everything else that we already voted on. So no other change except for the definition section. So if everyone could take a look at that and speak up with any questions or comments. Any questions or comments on the definition? Okay, can we just go to the bottom 5.0 and 6.0, Lindsay? And I want to make sure that I'm reading this correctly. Yeah, thank you. Thank you for making those changes. So the task requirement for recertification, is that right? So when you're doing recertification, you have to show during the 5 years prior, and then education requirement, is that at least 60 hours? So basically it's 45 for the initial application, 60 if you're doing it without the exam, and then to be recertified. So I already have the certification. This is now past the first 2 years. I'm getting to be recertified. We're going to require 60 hours. Is that right? Okay, so I did want to call that out because I think that is a little bit that we did not discuss that today. So that is in addition to, we talked a lot about the initial certification. This will be for recertification, which will happen after the 5-year period. So those are the only differences. Otherwise, it's everything else. I'm just making sure that's correct. We talked about the task requirements. We talked about the education requirements and the alternative. And so, yeah, that's it. So 1.0 definition and 6.0 education requirement for recertification is the only information here that you have not approved previously. Any questions or comments on those two sections? Otherwise, we can quickly make for a motion to approve and go to next steps.
And as well as we'll need 2 volunteers for this as well.
For cleaning this up?
Yeah, so the education requirements are wrong. We need to update the standard, so we might as well get those now while we're at it.
Okay, what is wrong? What do we need to, is this not reflecting what we just approved?
So all the standards are wrong on the State Bar website. So specialists used to have to report education every 5 years, but in 2014 it was changed so that they reported at the same time as their general MCLE, which is just 36 hours every 3 years.
Oh, I see. So instead of 45, now this is 36, is what you're saying.
Well, the section 6.0 it looks like at least is wrong. I'd have to look at 3.0 closer, but for sure
So
for
are
sure
you saying
6.0
that
is wrong.
this is a technical thing, and it's not something that the privacy law group has to discuss? We're just going to have this mirror what the state bar requires, right?
Well, I don't want it to mirror. Let's get it right now, so we don't have to, and then
Oh, okay.
we'll work on the other ones, and we'll just get them approved as a batch.
So you're going to tell us how to fix this now?
No, that's why we get 2 volunteers.
Oh, I see, to fix it. Sure. I'm happy to work on it since I've asked Ryan and Lindsay to work on the other one. I'm happy to work with you. Do we have another volunteer?
So we could also have the volunteers work with staff, so we could provide a little guidance on this process as well.
Oh, I see. So it could be me and one of the staff working on the standards. Okay.
Like we would supply like that
would be great. That's a great idea. So can I just make sure I understand? So this is not something that the privacy law group has to opine on. We're going to basically the 2 volunteers, and I'm volunteering to be one of that, is to work with you to have the standards mirror the latest standards requirements by the state bar, which was established in 2014, because we got this off the website and I guess we didn't have the right info. Is that right?
Yes, and then you'll incorporate the recommendations for PLG into the new that standard.
Okay.
And it's my understanding also that the 2 members or the 2 volunteers are also just going to ensure that the whole packet is like finalized before it goes to CBLS. Is that the case?
Okay.
Or was
yeah,
it
I think so. Although I think we did not ask for. I think the very first section we asked for 2 volunteers. The proposed standards, because I think that's the proposed standards. I think probably need some cleaning up. Like ordering and things like that. Technical changes, but The other, the task and experience, the exam topics and the alternative exam, I don't think needs a lot of changes, but are you saying that you would rather?
Oh, no.
Should I make a motion to have Ryan and Lindsay work with the staff in looking at all of them so that the whole package is, cleaned up?
I just wanted a clarification. I wasn't suggesting that what we should go one way or the other. But we definitely I get you the staff support for this portion on the standard. But I just wanted to clarify the next piece, which was the initial conversation about the 2 volunteer PLG members.
So what was my understanding as staff was the 3.1 one was for them to, the volunteers would take their time to clean up everything, if I'm not mistaken, for 3.1 and then submit it as a clean version for the package. And then with the changes that Lindsay has been making throughout this, with exceptions to this one, which staff will be working with 3.5, it looks like things are looking okay for submission for all others but this one and 3.1.
I think so. I think that's what I am suggesting, is that I don't think we need cleanup for the other items. 3.1, Ryan and Lindsay will work on, and I will work with one of the staff members for 3.5. That way, only 2 people are working on, one thing or another. Would that work?
Yeah. I just want to clarify, and I'm not trying to be difficult, but I just want to make sure that when we voted for the items, like, for example, when we voted on 3.1, was the vote Janelle, do you have the language for that motion? Because the issue is, like, if there are some modifications, does the motion reflect that?
What I'm understanding is they voted on everything to be as is, but they would just be making the changes to the acronyms and just cleaning up that information. So I'm unsure if I needed to have a motion on that specific.
I think what Amy is saying is, and let me see if I can try to clean up, because I think that was me. So let me see if I can restate the motion correctly. If I missed what you're looking for, Amy. I think I made a motion to allow Ryan and Lindsay to make the technical changes, like ordering and whether we want to capitalize things, that kind of spelling and formatting changes. And after those formatting changes are made, then this copy that Ryan and Lindsay makes technical changes to will be approved to go to BLS. That was my intention. Did I not say that very last part? And do I need to do it again? Do I need to make another motion?
No, I just wanted to make sure that the motion reflected the motion reflected the effort, that
correct. Yeah, that was my intention. Please let me know if somebody has notes from my previous motion, if that was incomplete.
And if it was, we could just accept a friendly amendment by both the individual who moved and seconded, and the vote still stands.
Okay. All right. Then for this, I would volunteer to work with one of the staff members. Do we need to identify the staff member that's going to work with me?
I don't think it's necessary. Yeah.
Okay. So the state bar will let me know what the standards are, so that this is accurately reflected. And we will, so the motion is that I will work with a staff member to make the edits to reflect the correct standards for certification and recertification. And the PLG is voting to allow us to make those technical changes and present the final copy to BLS with those changes. Did I capture that right? Okay, that's my motion. Is there a second?
Second.
Corinian,
Approved.
Soleil,
Approved.
Sharada,
Approved.
Martinez? Martinez? Krolik?
Approved. Sorry.
Thank you. Krolik?
Approved.
Isri?
Approved.
Jaworski?
Approved.
Yunaka?
Yes.
Thank you. Lenoy?
Approved.
Hershenson?
Approved.
Davis?
Approved.
Rajmohan? Choi?
Approved.
With 12 yeses and 0 noes, the motion passes.
All right, so we will now move on to item 3.6, where I will summarize the next steps for the PLG. And here they are. So for next steps, the PLG proposal will be presented to the CBLS at their December meeting. Once the CBLS approves, the proposed standards will be presented at the Board of Trustees meeting to open the 90-day public comment period. And after that, it will be submitted to the Board of Trustees for final approval. The Board of Trustees is set to discuss a new schedule at their November meeting. If the proposal to reduce meetings from 6 to 4 months is approved, the board will address rules at all meetings. If either committee indicates that a change is needed to what we submit, the PLG will convene to implement the necessary changes as requested. If there are no changes, then this is going to be the final meeting of the consulting group. So again, the next meeting for the PLG is to be determined and will be scheduled as needed depending on how this goes. A follow-up email from Janelle summarizing today's meeting is going to be provided, and any additional information as it becomes available. Are there any additional comments or questions? Okay, so with that, we will be adjourning the meeting. I just want to say thank you to the State Bar and all of our PLG members for the opportunity to work on this exciting project. It's been a really exciting and interesting exercise. This concludes all open session items, and there are no closed session items on today's agenda. And so I hereby adjourn today's meeting.
Thank you.
Thank you.
Thank you, everyone.
Thank you.
Have a good weekend.
Thank you.
Thank you.
Bye.